commitment through marriage.
John Eastman.
I disagree. Actually, on the prediction, I fear that he may be right. But on the merits of whether that's right or not, I think I disagree vehemently. We're not talking about marriage equality. We are talking about dramatically altering the nature of the institution of marriage. And both decisions, the DOMA decision in the First Circuit and the Proposition 8 decision by the Ninth Circuit, didn't apply strict scrutiny because it found a fundamental right to marry whomever you want without regard to the opposite gender. That's never been held by any Supreme Court decision. And it didn't apply strict scrutiny because it found that gays and lesbians were a suspect class comparable to race. Either of those decisions would have been intellectually more coherent. That if I apply strict scrutiny, the government has to have a compelling interest for its classification. And the classification has to be narrowly tailored to further that compelling interest. That's not the basis of either decision. Both courts held that this didn't even pass the lowest level of constitutional scrutiny we give, what's called rational basis review, where if there's any conceivable reason for upholding the classification, we defer to the government. The notion that I can't conceive of a reason for keeping traditional marriage between opposite-sex couples who have the possibility of procreating and then raising the children that are the offspring of that relationship, something that doesn't exist by nature in the other type of relationship, that's not a statement that evidences any hostility or animosity. It's a simple statement of biological fact. Under rational basis review, that is more than sufficient to uphold those statutes. For the courts in both of those cases to say that this doesn't even pass rational basis review is to impose on all 7 million Californians who voted for Proposition 8, the majorities in every single state, all 32 of them that have voted on this issue, and the federal Congress that overwhelmingly passed DOMA in 1990s with President Clinton's signature, it's to assign to them nothing legitimate but only exercising animus and illegitimate stereotypical animus toward gays and lesbians. And in fact, it's to ascribe that animus to the entire history of Western civilization. That's what's at stake, to say that there's no possible explanation for keeping traditional marriage other than hatred of gays and lesbians. I don't think Justice Kennedy is prepared to take that step. He specifically keeps the question open in Lawrence versus Texas, and he also spends a lot of time in that case pointing out how the anti-sodomy statute in Texas was a statute that existed in only a few states anymore. That's not the case with marriage. And in fact, this inevitability claim that civilization is changing, every time it's been put to a vote, every time, to the people, traditional marriage has won out. This is not some outlier by some hick state. California voted for Proposition 8. The United States Congress voted for the Defense of Marriage Act. I think that makes it dramatically different. Now, you can't read the tea leaves in those two opinions by Justice Kennedy to think that that reasoning, that difference...
Stay calm.
You see what happens when you mess with traditional marriage.
That could end up on YouTube.
In any event, I do share Erwin's view and what his optimism and my concern, that the tea leaves of Justice Kennedy's opinions in both of those cases suggest that he might be inclined to vote to strike down Proposition 8. But the reasoning, the things he actually says in those opinions would allow him more than ample reason to distinguish the case if he so chose, and I hope that he does.
Erwin, I'm going to give you the opportunity to interpret that event.
My field's constitutional law, not geology, so I'll stick with that.